Ladies and gentlemen, this is Emeka Wonye, and today is Thursday, the 19th of May. This is an opportunity for us to have a discussion on the case of Nnamdi Kanu after his appearance in court yesterday. So we do this from time to time. The purpose is to keep our readers and our members and followers aware of the latest development in that case, especially when there are instances of confusion and misunderstanding on the part of our members, judging from the comments they make on social media. For instance, yesterday, I read several comments saying Nnamdi Kanu's charges were struck out by the court. Yes, it was repeatedly said. Initially, I was surprised why anybody would believe that. But I later discovered the source of that confusion. That is, the belief or the statement that the amended charges against Nnamdi Kanu were struck out. And that caused some people to celebrate. Some of his supporters just assumed that all the cases against Nnamdi Kanu have been withdrawn by the government or struck out by the court, which by implication would mean that there are no pending charges against him and that he is a free man and could walk out of court free. That wasn't what happened at all. I've tried to explain the basic thing that I call it basic thing because it shouldn't really cause any confusion. Remember that Nigerian government had filed several charges against Nnamdi Kanu. They amended these charges. Each time you amend a charge, either to add a new offense or to remove some old offense, we call it an amendment of the charge. And each time a charge is amended, that charge has to be represented in court as new indictment. And then arraignment will also have to occur. Arraignment is when a person is formally presented before a court and informed of the charges against him and be given an opportunity to plead whether he's guilty or not guilty. That's what we call an arraignment. Each time a charge is amended, the accused person will be arraigned. That is why you have had this reoccurring in the Nnamdi Kanu's case. I take you back to a few trials in the past in this case. The government came with 15 amended charges. Why was that an amendment? Because this is actually a continuation of the 2015 charges, or charges originating or relating to the 2015 arrest of Nnamdi Kanu. So he was formally charged for the first time in 2016. Then the government came with, I believe, 8 counts or thereabout. Eventually it was brought down. But after Nnamdi was caught in Kenya and brought into Nigeria, he was detained, first brought to court on the strength of the old charges, that the 2016 charges. However, the government felt that a lot of other things had happened since 2016 that they needed to amplify the charges, that they needed to add more charges. Of course, we anticipated that. Many of you who've been listening to my analysis of this case, I warned you that the government was going to amend those charges. And the government amended the charges, bringing it to 15 count charges. Nnamdi's lawyers fought against the charges, asking the court to quash the charges, to strike the charges, that they were not of any merit. They won halfway because the court agreed that some of the charges were wrong, were a repetition, and did not disclose specifically or clearly enough any particular offense. So the government struck about 8 counts of those charges out. Government struck out 8 counts. And when government struck out 8 counts, it meant that some of the counts, some of the 15 counts were no longer valid and could no longer be presented, and that Nnamdi could not be tried on those that the court has struck out. So now, you have a charging sheet where some of the counts are valid, some of the counts have been struck by court. It creates confusion. Because when you mention these counts, you say count 1, count 2, count 3. And then what if count 4 was struck? Then you have to say, you jump count 3 and then go to count 6 or count 5. It creates confusion. So invariably, what the prosecution would do is to take that 15, the charges sheet with 15 counts and remove those counts that have been struck out. After removing them, they will bring them back and renumber those counts. They will now renumber 1, 2, 3 to whatever remained. So that's what the prosecution did. The prosecution re-amended the amended charge, bringing in 6 counts instead of 15 counts. So there are so many reasons why the government could do this, because apparently the 6 new counts were actually more in number than what the court had preserved after striking out some counts. So what happened yesterday in court was that because an amended charge was filed, technically you can say that the case was reset to start all over and Nnamdi will be rearranged. But of course, Nnamdi's defense counsel, in their judgment, I can't question that judgment because I do not know what informed their decision. But the lead counsel, the senior advocate, Ezekiel, did not want his client arraigned immediately. He said, I just have been served. I need an opportunity to study this new charge and the counts in them so that I can advise my client. That's a legitimate argument to make. But the prosecution says there is nothing new. These are the same old things. We just repackaged it and brought it back. There is no need for waste of time. But the court knows it is better to err in the direction of allowing the defense counsel the short opportunity they requested to brief their clients, to read the new counts and be better informed and be able to guide him. What sort of guidance would Ozekome give Nnamdi Kanu? He's going to plead not guilty to all of them. Since he's going to plead not guilty to any charge from Nigerian government, there is no need to study the charge before arraignment. No need at all, because guess what? He will still plead not guilty to any of them. Assuming you said, well, I want to study it to know whether he could plead guilty to some of them and not guilty to some of them, so let me advise him on that decision. But that's not going to happen. He's not going to plead guilty to anything. Therefore, there is no need to get up. But again, as I said, I'm not questioning Ezekiel's judgment. He is a senior lawyer and a well-respected lawyer in this country. So if he chose that approach, he must have his reasons. All right? So now, when you amend a charge, you're going to bring a new charge. So what does it mean? There are now new 2 charges. The one that is there and the one that amends it. So normally, for you to present the amended charge, you have to ask the court to strike the old charge so that it can be replaced by the new charge. That was what I believe happened in court. The court struck out the amended, the old charge, struck them out to bring in the new one. So when people began to say, people assumed that it was the new one that was struck out. So of course, if the new one has been struck out, then Nnamdi Kanu is a free man. Then the government has no further case against him. So when people wrote these things, and I read the comment, some people even asked me, I said to them, it's not possible. It's not possible because if all charges were struck out in the manner they assumed, Nnamdi Kanu will be walking home. There will be no legal basis for any further detention. The court will have to discharge him at least. So that wasn't what happened. If you pay attention, if you are well informed, or if you're an expert on these things, it is really not difficult to understand what is going on in Nnamdi's case. It's a very straightforward issue. The government had come up with these theories of treasonable activities. And the government is having a hard time. I must say that the government is having a hard time building a case, which is a surprise. The government had had 6 years to prepare for this case. They shouldn't be having the kind of difficulties I'm seeing them have, because for the court to strike 8 counts out of their 15 counts, it tells you something is wrong with the prosecution. How did we get it wrong 8 times? If the court says, well, they were repetitive, why would you file repetitive charges? You should know better. So I respect LeBron, the prosecuting counsel. I've met him in the past. He's a nice guy, I can tell you that. But I am not comfortable with the manner in which this case is building up from prosecutorial point of view. Why so many amendments? Why have your counts struck out? So many of them struck out, not 1, not 2, not 3, 8 struck out. That's actually the court telling you that you messed up 8 times, that you got it wrong 8 times. How can you get it wrong 8 times in one single indictment? That's a problem. That's something LeBron has to deal with. I don't want to blame him because he's a lawyer. The lawyer relies on what the investigators give him. The DSS are building up the case, investigating the case, giving him things, proof of evidence and materials. He needs to prosecute the case. He's relying on DSS for that. So if DSS are not getting their acts together, it's going to result in the prosecuting counsel also not getting his own acts together. And that's what I'm sensing here. There's no other way to explain what looks like a blunder on the part of the prosecution. Then on the part of the defense, there's a whole lot to say, but that's going to be another time. There is something else that came up yesterday. Many people heard about it. The government is actually accusing some of the defense lawyers of being accomplices, being, complicitous in these events, in the offenses, and that's the problem. It didn't come to me as a surprise. The role of Barrister Fanny Ejiofor has always been a problem for me, and I have said it in the past. His role in this case, is he a lawyer for IPOB? Or is he a member of IPOB? Or is he an executive of IPOB? That is a very delicate thing. There's a line there. When a lawyer is acting as a lawyer, he enjoys immunity. He enjoys protection. He's free. He has some latitude. But it's so easy also for a lawyer to cross that line and become part of the people he represents and begins to further their activities. So, if Ejiofor was representing Nnamdi Kanu, but speaking with Emma Powerful, who is not his client, and if Emma Powerful is an outlaw from the point of view of Nigerian government, so the interactions between Emma Powerful and Ejiofor will become questionable, because Emma Powerful is not Ejiofor's client. Emma Powerful is not a witness in Nnamdi's case. So, on what basis would a Geoffrey be speaking with the more powerful? On what basis will a Geoffrey be speaking with IPOB members who are not his clients? If he's doing that, he crossed the line. And that is something that tells you that Nigerian government is not really as mischievous as it could possibly be. If the government wants to play hardball, they can indict a Geoffrey. They can indict any of their lawyers who interacts, communicates with any other member of IPOB that is not his client. You have immunity when you are dealing with your client. Whatever your offense your client commits, you are free to talk with him. Nobody's going to question you. Nobody's going to question you if you receive your fees from your client. If your client pays you money for your services, you're free. But if someone else who is not your client and who himself is wanted by government begins to interact with you, you're crossing the line. So I think what the government did yesterday was to fire a warning shot, to bear its fangs, to say to Ifeanyi Geoffrey, hey guys, we can come after you. We have the basis to come after you. So be careful. So what should Ifeanyi do? What Ifeanyi should do is to withdraw. He cannot be a defense counsel. There had been a subtle threat thrown at him. If you understood what it meant, he should withdraw. Because essentially, he's going to go to bed knowing fully well that if the Nigerian government wants, they could charge him with complicity or being an accomplice or other offenses relating to the same offenses that Nnamdi is charged with. So, this case is going to be interesting. We are continuing to monitor it, and we will continue to update our members. The goal is to keep them informed, because in this age and time, you read a lot of things in the social media that you end up being more confused than when you started reading. So to cure this confusion, we will help our members by giving them the sort of knowledge that could come only from experts. So they will understand what is going on, be properly informed, and be able to resist the temptation of the misleading, sensational stories they read in the social media. Thank you so much, ladies and gentlemen. We shall continue this update.